Hello guys, this is the presentation for business law, and this is our group, and we are presenting about the case of Australia Safeway Stores versus Jaluzna, and myself Roshan Adhikari. My student ID is NVA8048.
I am Babita Umagai Sapkoda. My student ID is OED 8015.
And I am Rosni Paneru. My student ID is TIA 8105.
I am Sandhya Gurung and my student ID is TIA 8047.
Here we are going to present the presentation, and on the top of that, the introduction of the case. I'm going to do the introduction and the facts of the case. Let me go through the introduction here. One morning, one of the customer goes to buy the cheese in the Australia Safeway stores. Unfortunately, it was a rainy morning, and she falls down on the floor because of the moisture on the tile, and she is claiming to the Australian Safeway store about the negligence and breach of duty and duty of failure to duty of care, and she is claiming for damage. In this case, Jaluzna is a plaintiff, and the Australia Safeway store is a defendant. And while going through the facts of the case, we can see that the plaintiff here is claiming about the damages to the defendant, saying that she got a personal damage, and the company shows no any customer care, and it lacks the duty of care on the customers, and because of such a negligence, she just fell down on the floor. This case was from it is from 1979, and it was an accident which happened while the customer was going to buy some stuff, and she just fell down, and which she claims that it was a negligence of the whole company for not providing the signs and the boards which they need as a wet floor. And the defendant, Australia Safeway Stores, is claiming that it was not their mistake, and being the reason the plaintiff was out of the premises of the company, they doesn't pay any fine for that, and they don't want to say that they doesn't provide any duty of care, because being despite of their premises, they just they just mopped the area already, but she fell down, which was an accident. And here my friend is going to tell you about the issues raised by both plaintiff and defendant.
Thank you, Roshan. And I'm going to explain about the issue. The issue was about a client, Jaluzna. She fell on the tile floor of Safeway General Store on a showery morning. She claiming that there was no standard of care or by an occupier of the premises to those entering the premises, and the issue raised by the plaintiff was damage for carelessness. Client was felt on the tile floor. She had a big physical injury on the floor of Safeway store in the showery morning. This is the standard of obligation that was broken by the Safeway store. Another issue was claiming for break of general obligation of care, and she also claimed that the breach of obligation owned by an occupier to an intensive was not the proper. Similarly, the issue raised by the defendant was there was no damage for carelessness, because it was the showery morning, and they had done the mopping on the floor. So obviously it was the natural that in rainy morning the floor will be slippery, and anyone can has damage or physical injury, or they can fall down. And the witness of the floor contributes for the weakness. Strap mall was not ligamentally in the charge of the missing, since it was just a client shopping in the stormy morning, and it was the appellant's party commitment to take the sensible care to keep harm from surprising risk. So they said that it was not their fault. Jaluzna needs to care for herself because it was raining, and she fell down. That was not carelessness of Safeway store. Now Rosni is going to explain about the argument between two parties.
Thank you, Babita. And I'm going to present the arguments between two parties. And the arguments arise from the two parties is duty of care. Duty of care between the person on whom the commitment is constrained and the person to whom it is owed. The association between an occupier of premises and his invitee. At the season of the inquiry, which initiated in July 1984, the precedent-based law regarding this matter was too much specialized and needed consistency. This procedure of arrangement regularly worked in a self-assertive way. The seventh ground of appeals raises two questions for consideration. The first is whether there was evidence establishing or trending to establish circumstance giving rise to a general duty of care, addition to any special duty imposed on the appellant as occupier of the supermarket. And the second question is whether the duty owed by an occupier of premises to an invitee in respect of the condition of the premises should be stated in the terms of Lord Atkins' speech in Joanna v. Stevenson 1931, rather than in the terms of the judgment of Willis J. in Intermuir v. Dems. The court held that the law around there ought to be abrogated and that the law around there ought be administered by the general standard of carelessness. This approach at that point turned into the law in the act. And the rest of the part, judgment and critical analysis, will be continued by Sandhya.
Thank you, Roshni. Now I'm going to discuss about the judgment of the court regarding Australian Safest Stores versus Jaluzna. Defendant claimed that plaintiff caused inside invitee classification and harm wasn't unusual in this manner no duty. The duty of care which His Honour held the appealing party to owe to Mrs. Jaluzna was the duty of care owed by an inviter to an invitee. Courts rejected the traditional way to deal with occupiers' risks and chose that, starting now and into the predictable future, the general duty of care recipe under Donahue and Stephen ought to be connected to all cases. In this case, we can see there is commercial relationship and also reasonable predictability. In this manner, there is a duty of care, since general duty of care can emerge from an assortment of relationship between the individual on whom the obligation is forced and the individual to whom it is owed. However, the uncommon duty of an inviter can emerge from yet one class of relationship, the connection between an occupier of premises and his invitee. And the last one is like court contended that when you anticipate the individuals will come into your shop and pay you cash, the least you can do is give a sheltered situation. Finally, I would like to conclude this case as very sensitive, where both plaintiff and defendant strongly arguing about duty of care and breach of duty. Court has decided this case in favor of Australian Safest Stores, hanging all the facts alongside. It's mentioned that plaintiff fall outside of the business premises. There are so many facts from where we can analyze and reasonably consider for making decision in this case. First, duty of care was fully provided for all the customers. In fact, plaintiff fall outside the business area despite the floor was mopped. Another main important thing is always personal awareness need to be shown on the rainy days, which prevents from personal damages. Thank you.
And unfortunately, one of our group members is unable to attend the presentation because of his health condition. His name is Ujjwal Paudel, and we would make sure that he had help us totally as we, all the members, did for all the presentation. And we'd like to say to our lecturer that please provide equal marks for everyone, because he is out because of his health condition, and he had totally cooperated with all the works we have done, and it's all we did is